Yes, good afternoon to everybody. Welcome to the class of this Transfer of Property Act of 1882. We will say that the Transfer of Property Law, which is the second year first semester course. In other words, we can say it's a third semester course for the LLB 3 by DC. Yes, yesterday that we dealt, because if you happen to see the syllabus, I will show you the syllabus here. Yes, we completed in the unit 2, Doctrine of Election, we completed. Then the two classes we took in the covenants only. In the first class, the covenant that I dealt with the covenant and its essentials or characteristic of it. In the second online class that I dealt with the types of the covenants, what is the distinction between the covenant, the two of the restrictive covenant and the imperative covenant, or we can say positive covenants, the difference between the two also that we did it. And yesterday, in the last class only, I told that I am going to deal the transfer by ostensible owner in this class. Let me see the what is the transfer by ostensible owner. Owner means we could know that. Anybody could say that what? Who is the owner? Yes.
Property owner వ్యక్తి.
A person who is having the title deed on his name, a proprietary, is said to be the owner. So he the sole authority that the owner can transfer it. So that is called the owner. Here, ostensible owner in the sense apparent. It looks to be the owner. Apparent, we will say. So transfer by the apparent owner. What is that? We will see the explanation first. Let me see the explanation regarding the ostensible owner is concerned. Yes, that is clearly mentioned in the section 41. The 41 of the Transfer of Property Act, it clearly says where with the consent express or implied, expressed by the words, implied by the doing their act of the person interested. You should have interested in the immovable property, and these owners, especially the ownership. Ostensible owner means it is concerned only to the immovable property. A person is the ostensible owner of such property and transfer the same for consideration. So another point is there, it is clearly said for the consideration is a very important factor. That means it will not be applicable to the gift. It will not applicable to the gift, but it can be applicable to the mortgage, it can be applicable to the lease also. But a transfer is for the consideration is there. For gratuitous transfer, ostensible owner cannot do so. So the transfer shall not be voidable, shall not be voidable. Means if the ostensible owner will transfer it, it should not be voidable on the ground that the transferor was not authorized to make it out. So here the ostensible owner is the transferor. The other person who is getting the property is called the transfer. So ostensible owner is the transferor here, not the original owner. So provided that the transferee means the person who received it after taking the reasonable care, that he has to take the reasonable care to ascertain that the transferor means ostensible owner had a power to make the transfer, has acted in a good faith. So in good faith, you should have to try to make it known that whether he is the real owner or not. Suppose if you are going to purchase a immovable property, so naturally, what do? You see the who is the owner of the property. So how could you know the who is the owner of the property? What you have to do? What is your step? Anyone for the immovable property? Yes. Anyone can unmute and give the answer.
అంటే రిజిస్ట్రేషన్ పేపర్స్ ఉన్నాయేమో ప్రాపర్టీ మీద చూస్తారు.
Okay, that registration paper is there on his name or not. Suppose registration paper is there on his name, but he may be mortgaged the property.
దానికి ఒకటి
సార్
Yes.
సార్
ఈసీ సార్
EC encumbrance certificate. Where do you get it?
Registration office.
A registration office that you have to apply for the EC. Nowadays, EC can be applied through the MeSeva also. So
Yes.
there you will get a certificate that this property doesn't have any encumbrances, neither it is a mortgage, nor there is anything on this property, and it is not put it in the bank loan also. So that's why that everything will be known there in the registration office, because whenever the property would be there, generally it should be registered. Even For the Benami also, it will be registered. Of course, because of the Benami Act of 1988, now the Benami transactions are wide. Even the person who is the Benami and who is the transferor here in this case law, he is having every right to transfer it.
Sir.
Yeah. So now, of course, in 1988, the position is different. But we have to read what is that, how a property could be there. Because many people are there when there are properties, when their income is more, means not white money. A white money, he cannot construct a ordinary house by taking care of the wife and children, father and mother, even father-in-law and mother-in-law, and their other relatives also. So now, if you have the black money, what they do? The people do. They will not buy on the property on their name. So buy the property on the name of the distance relative or wife side relatives or himself relatives, father, brother, sister, son, so on so forth. They will buy the property on their name. And tomorrow, if they want, they can sell the property also, because Benami, that is the act is which has come over there. With that, this will not, they will not be called ostensible owner. They are said to be the real owner now, because of the Benami transactions are there, which are wide. So now let us see that provided the transferee, after taking a reasonable care, he has to take it to ascertain that the transferor had a power to make the transfer. In another words, also sometimes now the property will be selling out with the very worth property is selling out. At that time they will publish in the newspaper also, the local newspaper. This property is going to be transferred or going to be purchased. If anyone is having any objection for this property or claim over this property, please bring to my notice or to my advocate. So that's the notice also will be given in the local newspaper, so that a legal complications would not be there in future. So this is the way the ostensible owner means apparent owner. Actually, he is not the owner. He is apparent owner. He looks to be the owner, but the real owner is different. Now, how could you know that he is the apparent owner or not? We have some of the characteristic over here. We are going to study it. The following persons have been considered to be the ostensible owner. So now, who will be the ostensible owner? Now let us see that. Number one, who is the apparent owner of the property? Suppose, and we don't know who is the owner of it, because that property, that the land or building, he is using it and is giving the rent, and sometimes he himself is using it, again giving the rent and making the thing. People think that he is only the owner of the property. But when they clearly see the documents, he is not the owner of the property. But somebody is the owner of the property. But all the transactions this fellow is doing, mortgaging, leasing, and doing all other things he is doing over there. So at that time that we will feel that he is the owner of the property. So who is the owner of the property? It means who is the apparent owner of the property is number one. Number two, who may be the possessor of the property. Again, the next point is the property which is there, he should be in the possession. He is the possessor of the property. That's why the common law principle says. What the common law principle said regarding the possession? Yes, anyone? If you are my law taught student, definitely that you will give the answer to my question. What is the maxim?
Yeah.
The common law maxim is there. Yes.
ఎవరైతే ఆ ప్రాపర్టీ మీద ఇప్పుడు అట్ ప్రెజెంట్ ఎవరు ఉంటున్నారో వాళ్ళని పొజిషన్ అంటారు సార్.
దాంట్లో ఒకటి ఉన్నది, ఒక కామన్ లా మ్యాక్సిమం ఉన్నది. పొజిషన్ ఈజ్ 99% ఓనర్షిప్.
అదే సార్, దాన్నే కబ్జా అంటారు.
Yes, that is the call. Possession is 99% ownership, because that is the law, common law principle would be there. Then second condition should be fulfilled. The third condition is who has all the indicia, means distinguished marks of ownership, without himself being the real owner. Suppose people think that who is the real owner, they don't know actually. But this fellow will act as everything, every transaction that they will do it. Of course, we will do it because of the consent will be given by the real owner. Number one, either express consent or implied consent. So in the both the way that he can do it. So he has the indicia, distinguished marks of the ownership without himself being the real owner. That is the third characteristic. And the fourth one is who will not have a valid title but is able to transfer a good title. See, he is not having the valid title, but apparently law protects. Law section 41 protects over there. Suppose somebody's property A is there and B is there, and B is very known to A is very known to B. when the B is selling the property to C, signing it, and A is keeping quiet. That means impliedly he has given the consent for selling the property. Are you following me?
Yes, sir.
So that is that we will, because A is also present over there when the transaction is going on, when he is the owner of the property. So that is the another characteristic that he will be the ostensible owner, and who is not the real owner of the property. He is actually is not a real owner of the property, but he is allowed by the real owner to hold himself out of the world as the owner. But he allows him. Yes, he take the position. He will keep the guest. He will mortgage it. He will lease it. He do everything would be there, as if there is a GPA is given to him. General power of attorney is given to him. In that way, that he will act it. But generally, there is no general power of attorney. If the general power of attorney is there, naturally he will be the real, a real owner to transact the business.
Yes, sir.
Even though there is no necessity having the knowledge of the owner, there is no necessity having the signature of the owner. Because in the law,
Yes, sir.
he is said to be the owner in the eye of the law. So that is how he is not the real owner of the property, yes, but he is allowed by the real owner to hold himself out to the world as the owner. So that was the thing it is made in the fifth point. And the sixth point is who is taught not the real owner of the immovable property. Who is taught not the real owner of the immovable property, but makes a belief the outside world as the real owner. In fact, he is not the real owner. Okay, but makes a believe that outside the world as the real owner. For instance, చిన్న అబ్బాయి ఉన్నప్పుడే 1 month 2 months అబ్బాయి ఉన్నప్పుడే అమ్మాయి ఉన్నప్పుడే అంటే శిశు ఉన్నప్పుడే ఇన్ఫాంట్ ఉన్నప్పుడే సిబ్లింగ్ ఉన్నప్పుడే యూ బ్రాట్ ద బాయ్ అండ్ you are taking the adoption of that boy and you are taking the care of him. So that boy doesn't know that he is the real biological father or biological mother, because that boy will thinks that you are the father and you are the mother only. No, a later part that he came to know that they are the real father and mother because they adapted it. Even the real father mother also comes, he will say, okay, uncle, how are you? He will say. Do you agree?
Yes, sir.
Because generally because he thinks because rearing people are there, so they think that they are the real one. Of course, after sometimes then he comes to knowledge, he will give also the equal respect to him because of necessity, because of his request, or because of a lot of children would be there and he is given for the adoption. So that is a different issue, that is a legal adoption would be there, and hence it will be run into the picture. So now the question comes, people think that they are the real owners unless until they will declare themselves they are not the real father and mother. Is it correct?
Yes, sir.
Yes, that is true. So, who is thought not the real owner of the immovable property, but makes believe the outside world as the real owner. So that is the sixth condition. And the seventh is who is an authorized owner with the consent, express or implied, the person interested in the property. So either the express consent or the implied consent by the real owner make the transaction, and he will allow him to do so. At that instance, he is also the ostensible owner or a apparent owner, who is a person who obtains the title in the property for which payment is made by another and therefore known as the holder of the property in Benami. So now we will say even this doctrine of this what I say, we can say this is also a holder of the property. Like the ostensible owner can also be known as a Benami property or doctrine of the holder of the property also. So who is a person who obtains the title in the property for which payment is made by another. So actually the another payment is made, but he himself not, but he in his name, and therefore known as the holder of the property. For instance, many people, they will buy the property and the wife name, they buy the property and the wife sister's name or other relatives name on the Benami property, and they are the holder of the property. But actually the where is the source of income for them? Nothing. But who purchase? The husband will purchase. On whose name? Wife name. So they are called the holder of the property in Benami. So actually the original owner is different and only apparent owner on his name, it will be purchased over there and he is the possession of it. Then we can say holder of the property also, we can say Benami property. So these are the people, those who can say they are the ostensible owner. So now we will see who is not who is not an ostensible owner. A person having restricted rights can't be called the ostensible owner. The following person are not being held to be the ostensible owner, because these persons are not, even though they are having the right, but they don't have the absolute right over there. They have only the partial right. Like number one, a trustee in a trust. A trustee can take the care of the trust and see that the benefit go to the beneficiaries to on whom the trust is formed, because those beneficiaries are minor, number one. Number two, the person who is a settler, he will who formed the trust, he will believe that these people will eat away and nothing will be left to them after some time. So that's why a trustee in a trust, he is not a ostensible owner. His only duty is to take the property of the trust and see that the beneficiaries will get the benefit, usufruct of the trust. That is number one. Number two, Karta in a joint family. In the co-personary, in the Hindu joint family is concerned, and who is the Karta, and he is not the ostensible owner. So that is because he has to take the permissions of the other joint family members. Okay. Of course, he will be the key person, but he should take the consent. A karta is not a ostensible owner, and a guardian of a minor. Suppose if a guardian is there appointed by the court, or it is there in the will, or by any other means, he is a guardian of a minor. At that instance, also he is not a ostensible owner, because when he want to sell the property, mortgage the property, sometimes most of the time he has to take the permission of the court. So because the limited power would be there for the guardian. So that is the number three. Number four is a licensee in a possession of property. Suppose you have the license to be on that land for some time. Like the licensee means a person who goes to the movie, a theater, is the licensee, and he will sit there and he will enjoy there and he will be on the premises till the movie ends, about 1 hour, 2 hour, 3 hours. So in that way, it can be movie will be over up to that extent. Can he extend his stay over there for the second show? Suppose you purchase the first show ticket.
No, sir.
Yes. No. Did you see a cinema where the two intervals are there? What is that movie? Even I also forget, and actually I remember the movie. It is a classical movie. It is a Purana అంటారు కదా అది. ఇది దేవతల దేవులది.
అవును సార్.
So that movie, there are two intervals because there is a 3 hours movie, roughly.
శ్రీ వెంకటేశ్వర మహత్యం సార్.
Is it? Or Pandava Vanavasam?
Yes, sir.
Something, a classical movie would be there. The two intervals will be given over there because that is a lengthiest movie. So now the point is, with the two intervals, they can sit over there. After that, two intervals and movie is over. Now you should vacate the premises, otherwise you will be called as a trespasser. So a licensee in possession of the property, no, he cannot do his. He can enjoy the property, but he cannot dispose the property. He is not a ostensible owner, even though he is on the possession of that property, or he is on the property. So a menial servant in occupation of a property. Suppose if a person would be there who is taking of your house, like a watchman. Can a watchman is ostensible owner?
No, sir.
No. He is a servant in occupation of the property. He will only safeguard the interest of the property. See that the property will not be taken away or looted by the antisocial elements. So that is only the person. And then number 6 is a manager or a trustee in idol. So a manager of a purohit. A purohit, not can he sell the jewels of the idol? Jewelry. Answer no. Because he is merely a manager. He looks not a apparent owner, like a ostensible owner. So a donor who has not reserved to himself any power of revocation of the deed of gift. Even a donor has not reserved to himself any power of revocation of the deed of a gift. Suppose if he doesn't have the revocation of power over there, at the time also he is not a ostensible owner. So a donor in position. So a person who is a donor who is having in the position, still he is not a ostensible owner, because whenever the donation will be given over there, it should be given unconditionally, absolutely. So that is under physical transfer should be there. If it is a movable property, if it is a immovable property, if the transfer, the names, title deed should be transferred to the donee name. If it is a donate, of course, for a donations, for a gift, the stamp duty is less. So a mahant of the mat, suppose a purohit, a mahant, a father of a particular diocese, at that instance also he will not be ostensible owner. A professed agent or a manager. Here a professed agent or a manager, because generally a professed agent you will say at that instance he is like a broker. Can a broker will transfer the property?
No, sir.
Answer no, he will only work as a commission agent
Yes, sir.
and he will take the commission. And if a transaction will be made by the either ostensible owner or is the real owner is. But he is only the liaison officer in one way, because we should not say now the broker, a liaison officer is. So now we will say that a professional agent or a manager also is not a ostensible owner. A mortgager. A mortgager also ostensible owner. The mortgager means a person who mortgages the property is called a mortgager. So a mortgager, once he mortgages the property, then we cannot say that he is an ostensible owner unless until the property is revert back to him. After the
Yes, sir.
mortgage money is paid. Is it clear?
Yes, sir.
Yes, that is the good spirit. So the provisions of its application lay down in certain requirement to avail the benefit of this section. So what are the ingredients we will see now? What are the ingredients should be provided, should be present in the ostensible owner or doctrine of the holder, that is a holder out, or we can say the benami. So now the first ingredient of the ostensible owner is the primary condition is that the person who is transferring the property should be the ostensible owner. Naturally, he is not the real owner, but he acts as the ostensible owner, as if that he is transferring the property. And the purchaser means the transferee also bona fidely believe that he is the owner of the property. That's why he is transferring it. So that belief also should be there. Number one condition that a transferer. Here the transferer means ostensible owner is the transferer, not the real owner. Are you following me?
Yes, sir.
Here transferer means only ostensible owner, and transfer means person who is receiving such a property is called a transfer. So number one, he should be ostensible owner, like the points which I have shown in the above. Number two, should be either impliedly or express consent from the owner of the property. The real owner of the property should have to give the consent, either express or
Implied.
implied. Suppose A is the owner of a necklace, and B is a very close friend to him, and every transaction of A, the B will do it. Even when he wants to buy anything, sell anything, even choosing the కాబోయే అల్లుడు or కాబోయే కోడలు ఎట్లా ఉండాలా, he will take the consult as if that he is a member of the family. So B has given in the donation to C in presence of A the jewelry, the necklace. So A kept quiet, and that means impliedly that he has given the consent to B to donate that necklace to C, who is a distant relative to A or a distant relative to B, doesn't matter. When A is kept quiet, means he is the owner of the property, he did not say anything. Of course, it is a movable property, that's why I am giving it. For the immovable property also, through the transaction can be made by the documents, because
Yes, sir.
you cannot give the position of the house. Okay, you can give the position of the house, you can give the position of the land, but when you want to transfer it, it should be through the document. So that is the point where that he is giving the express or the implied consent, means who is the real owner of the property. Yes, that is the second characteristic. And the third is there must be a transfer of property. Yes. How a property can be transferred? Anyone? Yes. How a property can be transferred? Mode of transfer.
Sale, mortgage, lease,
Yes.
exchange.
Yes.
Sir.
Will లేదా?
ఇంకా విన్నా
Will.
విల్ కూడా సార్ విల్.
Yes. And sale also.
Yes, sir. Sale.
So these are the
Sale
ways.
bill.
Where these are the ways where the property, can't we give you the gift?
ఎస్ సార్.
కానీ గిఫ్ట్ లో ఇవ్వచ్చు, లవ్ అండ్ ఎఫెక్షన్ ఉంటది. కాకపోతే సెక్షన్ 41 అప్లికబుల్ కాదు. ఎందుకు అప్లికబుల్ కాదు? అక్కడ చెప్పాం మనం, కన్సిడరేషన్ అన్నాం మనం, కన్సిడరేషన్ షుడ్ బి దేర్ అన్నాం. కాబట్టి గిఫ్ట్ వ్యాలిడ్, గిఫ్ట్ కి మాత్రం సెక్షన్ 41 మాత్రం వర్తించదు. కానీ లీజ్ కి వర్తిస్తుంది, మళ్ళీ మోటర్గేజ్ కి వర్తిస్తుంది, సేల్ కి వర్తిస్తుంది, కానీ గిఫ్ట్ కి మాత్రం వర్తించదు. బికాస్ ఇట్ ఇస్ ఎ గ్రాట్యుటస్ యాక్ట్, లవ్ అండ్ ఎఫెక్షన్, నో కన్సిడరేషన్. సరే కన్సిడరేషన్ ఏముంటదంటే లవ్ అండ్ ఎఫెక్షన్ అనుకుందాం అక్కడ, కానీ ఇక్కడ మాత్రం కన్సిడరేషన్ అంటే ఇన్ ద ఫార్మ్ ఆఫ్ మనీ ఆర్ ఇన్ ద ఫార్మ్ ఆఫ్ ఎ గూడ్స్. So when they say clearly in the section 41, consideration should be there. So there the consideration is not there, but in generally we'll say love and affection is the consideration. Hence 41 will not be applicable to the gift. So there must be a transfer of property. Yes, there is a transfer must be done, and it should be for the some consideration in turn. See, the fourth point is already made it. There is some consideration in turn written. Either it is a peppercorn also doesn't matter. Now the last point is the transferee has acted in good faith and with reasonable care. Suppose the other person who is a transferee who is receiving the property, at that time he should take some reasonable care, we have to take it out. So a person who wants to purchase a house, definitely he will first ask for the EC, whether this house is mortgaged or not, and they will publish it in their newspaper also if the worth of the house is high. And if nobody come forward at that instance, he can take it out of the house because it will not have any legal complications. Otherwise, no, the same land can be registered for 3 or 4 members in these days. Again, the dispute comes over there because I don't know what, because they will show the boundaries, different boundaries, and they will see that it will be registered. But anyway, that we'll say how it can be done. A good faith also very much, and a reasonable care should have to be taken by the transferee. A transfer by ostensible owner, let us see a few case laws so that we can go further. In the case of Surja Ratan Tirani versus Azamdabad Tea Company, Azamdabad Tea Company, AR 1965, Supreme Court 295, it was held by the Supreme Court that in order to attract the section 41, yes, in order to attract the section 41, it must be shown that the transferor was the ostensible owner of the property. So when you want to claim the section 41, at that instance you should say that he is the ostensible owner of the property with the consent of the co-sharers, where the property is the subject matter of the joint ownership. So with the consent of the co-sharers, if the co-sharers given the consent over there, okay, he can sell the property. Yes, when he sell the property, of course, whatever the amount will come, that amount will be given to the other co-sharers also. So where the property is the subject matter of the joint ownership, at that instance, and the transferor was the ostensible owner of the property. That is clearly mentioned. So in case of the Lakshman Chandar versus Kali Charan, that case law, a Privy Council decided that A during his lifetime, A is a person, during his lifetime made his wife as the owner of the certain immovable property by taking the sale deed in her name. So who paid the amount for the purchase of the immovable property? Yes,
husband, sir.
Husband has paid the amount, but husband paid amount, but he purchased on whose name? Wife name. So wife name, he purchased it through the name. So purchase, the money was paid out of their, after that money is not his own money, is a Sridhana. Sridhana means, yes,
like a dowry, sir.
dowry అంటారా because that property,
Kalyana
that
Lakshmi
amount,
money.
that amount, that gifts which come as her to her is called a Sridhana.
As a gift.
As a gift in one form, in another form.
Sir.
And at that time she is having ఫాదర్ అన్న ఇవ్వచ్చు, లేకపోతే పెళ్లిళ్ళ రావచ్చు, ఏదన్నా కావచ్చు అది. the property, he is the owner of the property,
అదే.
she can give to anybody because she is the owner of the property. So, yes, her Sridhana, the husband has purchased the house. So, after his death, wife sold the property to the defendants who purchased it bona fide and for the values. His son, his heir, sued to recover the possession of the property from the defendant. యాక్చువల్లీ ఆ ఫాదర్ ఏం చేసిండు, తన భార్య మీద కొన్నాడు. ఏ పైసలతో కొన్నాడు? ఆమె శ్రీధనతో కొన్నాడు. ఆ తర్వాత ఆమె హస్బెండ్ చచ్చిపోయిన తర్వాత ఏం చేసింది? ఆ ప్రాపర్టీని ట్రాన్స్ఫర్ సీకి చేసింది. అయితే ఇప్పుడు ఏ కొడుకు అంటాడు కదా, మా నాయన ప్రాపర్టీ అది, నువ్వెట్లా అమ్ముతావు, నేను నా హక్కుదారుని, నాకు కూడా వస్తుంది అంటాడు. అయితే ఇక్కడ ఏమంటారంటే, ఇక్కడ దట్ 8 sons ఛాలెంజ్ చేస్తారు, రికవర్ ఆఫ్ ది పొజిషన్ ఆఫ్ ది ప్రాపర్టీ ఫ్రమ్ ద డిఫెండెంట్ who has purchased the property. It was held that he could not recover position because of section 41. ఎందుకు సెక్షన్ 41 ఏం ప్రొటెక్ట్ చేస్తుందండి ఇక్కడ? ఎస్,
అది
Consideration.
వారసత్వ హక్కు కాదు కదా సార్.
ఆస్టెన్సిబుల్ ఓనర్ కి ప్రొటెక్ట్ చేస్తుంది. ఎవరంటే యాక్చువల్లీ శ్రీధనతోనే కొన్నారు. అది ప్రాపర్టీ వైఫ్ పేరు మీద ఉన్నది. At that instance, she is having every right to dispose the property because it is on her name. The property is on her name. At that instance, the son cannot say that no, she cannot transfer it because of section 41 protects the interest of the ostensible owner. Yes.
సార్ ఇక్కడ చిన్న డౌట్ సార్.
Yes, please.
సార్ ఇక్కడ సార్
Yeah.
ఫాదర్ కొన్నా మదర్ కొన్నా కూడా రైట్స్ సన్ కు ఉండవు సార్.
అప్పుడు హెరార్కీ వచ్చినప్పుడు, వారసత్వం వచ్చినప్పుడు, వీళ్ళ వచ్చింది అనుకోండి, వీళ్ళు లేకుండా వచ్చింది అనుకోని, వానికి రైట్ ఉండదా అండి? అప్పుడు
వారసత్వం అనేది వాళ్ళ మనవడికి మనవరాలకు వస్తుంది సార్.
మరి సన్ కి ఏమొస్తుందండి? ఇప్పుడు
నేను ఒక ప్రాపర్టీ కొన్నాను సార్,
సన్ కి ఏమొస్తుంది?
నా భార్య పేరు మీద కానీ ప్రాపర్టీ కొన్నప్పుడు
ఓకే,
సన్ కు వారసత్వం రాదు సార్.
అసలు ఏమొస్తుంది?
ఉండదు, ఈయన కొట్లాడడానికి.
ఇప్పుడు మనం ఇప్పుడు మన హిందూ మ్యారేజ్ యాక్ట్ ఎట్లా ఉన్నదో తెలియదు, కానీ ముస్లిం మ్యారేజ్ లో సన్ డెఫినెట్లీ గెట్ ద 2 shares అండ్ డాటర్ విల్ గెట్ ద 1 share. ఇది ఖురానిక్ షేర్స్ ప్రకారం.
సార్
బట్ ఐ డోంట్ నో వాట్ రైట్ ద సన్ ఈస్ హ్యావింగ్. కెన్ ద సన్ విల్ నాట్ బి లీగల్ హెయిర్?
హిందూ మ్యారేజ్ అలా లేదు సార్.
ఓకే, దెర్ ఇస్ నో సచ్ ఎ ప్రొవిజన్. బట్ యాన్సెస్ట్రల్ ప్రాపర్టీకి మాత్రం ఉంటది అనుకుంటా. యాన్సెస్ట్రల్ ప్రాపర్టీ డెఫినెట్లీ.
ఇప్పుడు భార్య భర్త ఇద్దరు కలిసి కొంటారు
కాదు, ఇది ఇప్పుడు శ్రీధనతో కొన్న ప్రాపర్టీ. ఇది
రైట్స్ రావు సార్,
అసలు ఎవరికి రైట్స్ రావు.
అవును, ఎవరితో కొన్నా కూడా సార్ ఆమె కన్సిడర్ చేయాలి తప్పితే వేరే ఉండదు సార్.
ఓకే,
ఇష్టమైతేనే ప్రాపర్టీ చేస్తుంది.
ఓకే,
దాని మీద ఎవరికి రైట్స్ ఉంటాయంటే హిందూ చట్ట ప్రకారము మనోడికి కానీ మనోరాలకు కానీ ఉంటాయి.
అచ్చా, బికాస్ ఆఫ్ ది ancestral property కాబట్టి. Okay. Then now the question comes over here. The Sridhana used it and it is on her name. At that instance, section 41 is applicable. She can transact the business that is a proper and not voidable nor void in this case law, which is Lakshman Chandra versus Kalicharan case law. So that is the transfer by the ostensible owner, number 1. Number 2, consent of a real owner. Whether real owner consent is necessary or not, let us see. The real owner is not responsible unless the apparent ownership of the transferor has been permitted either by the express words or consent or by acts or conduct which simply consent. Implied consent arises where the owner stands and allows the another to hold himself out as the owner of the property. It's the implied consent. Because he is present over there when the ostensible owner transferring the property, he did not say anything, means that he has given the implied consent. So acquiescence may under certain circumstances be taken to be consent. And తెలిసి ఉన్నది అనుకోండి, గమనం ఉన్నది అనుకోండి, that means he is having the give the consent to him impliedly that ostensible owner can transfer the property, of course for consideration. So Sarat Chandra versus Gopal Chandra, that is a case law. It has been held that if the real owner knows, actually real owner knows that the another person is dealing with his property, means ostensible owner, and if it were his own and acquiescence, and he takes it and he transacts it, and when he keeps quiet, inaction will imply that he has given the consent. Is it clear? రియల్ ఓనర్ తెలుసు,
సార్
మధ్యలో వాడు ఓనర్ కాదు, అయినా వాడు ట్రాన్స్ఫర్ చేస్తాడు, వీడు గమ్మున ఉన్నాడు అంటే కాన్సెంట్ ఇచ్చినట్టే కదా.
ఇచ్చినట్టే సార్,
ఇచ్చినట్టే, అది ఇంప్లాయిడ్ కాన్సెంట్ ఇది. సపోజ్ ఇఫ్ ఈ హ్యావింగ్ ఎనీ అబ్జెక్షన్, అరే నా ప్రాపర్టీ నువ్వు అమ్మడైందిరా అని అన్నాడా అండి?
అంటే
Yes, it is there. So that was the thing which has happened. So now the third point is transfer for consideration.
ఆటోమేటిక్గా జరిగిపోతుంది.
Yes. Because naturally ఇప్పుడు ఎప్పుడైనా సరే ఏదన్నా మీరు మీకు ఇష్టం లేదనుకోండి, ఇమీడియట్ గా మీరు ఏం చేయాలా? ప్రొటెస్ట్ చేయాలా. సపోజ్ మీరు ఈ ప్రొటెస్ట్ చేయలేదు అనుకుందాం అంటే అర్థం కాన్సెంట్ ఇచ్చినట్టే కదా ఒక విధంగా. ఓకే,
అవును సార్.
ఇప్పుడు ఎవరైనా అబ్బాయి వచ్చిండు,
ఓకే సార్.
ఒక అబ్బాయి ఇచ్చిండు, వాడు మామిడి పండ్లు మీ ఇంట్లో కోసుకున్నాడు, మీరు చూస్తేనే గమ్మున ఉన్నారు అనుకోండి, రెండోసారి వాడు వస్తాడు మళ్ళీ. ఆర్ యూ ఫాలోయింగ్ మీ?
అవును సార్.
Yes, that is the third. Yeah. So that is the implied consent అన్నట్టు అక్కడ. So now the third point that we will see, that is the transfer for consideration. So now we will see the protection of the section 41 of the TP Act is available to the transferee if the transfer is for consideration. Consideration untane section 41 applicable aitadi. If the transfer is gratuitous and free of cost, provision of section 41 would not apply. For if the gift, transfer section 41 will not apply. Transfer by the way of gift is outside the purview of the section 41. The provision of section 41 are applicable not only on the sales but on mortgage, exchange and lease. Applicable aitadi. So it is not applicable any act done gratuitously, number one. Number two, in the wills also, or in the gifts also, it cannot be attracted. Now let us see the Anoda Mohan versus Nilfar Mari. So in this case law, C's interest was protected as he purchased the property for consideration in good faith from B. I repeat, C's interest was protected as he purchased, who? C, purchased the property for consideration by paying the money or paying by the part payment or by any other means, and in good faith from B, thinking that B is the owner of the property and the ostensible owner. B is the ostensible owner, and where A, by his implied consent, created the ostensible ownership in favor of B by his inactivity. Suppose A kept quiet when the B is transacting. At that instance, A has given the implied consent to B that to act as the ostensible owner. At that instance, B can pass on a correct title deed to the C. So that is the whole idea, because there is a consideration. Because there is a consideration. So that is the number 3 point is, now we will see the fourth point, plaintiff acted in good faith and reasonable care. So the plaintiff acted in good faith and reasonable care. So that case law will see Khan Dhara Singh versus Union of India is a Punjab and Haryana case law, which is published in the AR 1984. The plaintiff migrated to India. అంటే ఎక్కడికి వెళ్ళొచ్చిందండి? ఫ్రమ్ పాకిస్తాన్ డ్యూరింగ్ ద పార్టీషన్. సో పీపుల్ migrated to India from Pakistan during partition. He had left some land in Pakistan. కొంత ల్యాండ్ అక్కడ వదిలిపెట్టి వచ్చాడు. అండ్ ఇన్ లీవ్ ఆఫ్ దట్, అది వదిలిపెట్టి వచ్చారు కాబట్టి దట్ ల్యాండ్ హీ వాజ్ అలాటెడ్ ల్యాండ్ ఇన్ ఇండియా. అరే నాకు 10 ఎకరాలు ఉన్నాయి సార్, నేను అక్కడ వదిలిపెట్టి వచ్చానంటే గవర్నమెంట్ ఆఫ్ ఇండియా ఏం చేసింది? 10 ఎకరాలు ఇక్కడికి కూడా ఇచ్చింది, ల్యాండ్ ఇన్ ఇండియా. It was found later on that some part of the land left by him in Pakistan. తర్వాత మళ్ళీ ఏం తెలిసింది ఆయనకు? కొంత ఇంకా వేరే ల్యాండ్ ఇంకా వదిలిపెట్టుకుని వచ్చిందని తర్వాత తెలిసింది. ఎప్పుడు? ఇండియాకి వచ్చిన తర్వాత. It was found later on that some part of the land left by him in Pakistan was mortgaged to Muslim. So some part of the land is mortgaged to Muslims. ఏది అది పాకిస్తాన్ నుండి ఇండియా వచ్చినప్పుడు later he came to know that is was mortgaged to Muslims later on. So a notice was served to him to pay the mortgage money back, but he did not. So this man, they said, who has taken the proportional land here, yes, you pay the mortgage money because he would like to give it back, that land. So therefore a part of the land allotted to him was auctioned. So whatever the land is given to him in India, it was auctioned. But the plaintiff did not challenge the order of the action in appeal. But the plaintiff did not made it, why you are actioning? Because they are actioning, the reason is they have to pay some of the money in the Pakistan where the property he is having is mortgaged. So this conduct of the plaintiff was enough to create a belief in the mind of the defendant that consented to the action sale, and therefore the purchaser acted in good faith in purchasing a land at the time of the action. So when the action was given over there, because really that the property was mortgaged there, and but here he said that he left the land in the Pakistan and he acquired the proportionate land in India. So these people will auction the Indian land to pay the debts in the Pakistan because of the treaty is there, and hence he has kept quiet means he's allowed the his the land to be auctioned over there, and that money will be given in the Pakistan to clear the mortgage capital amount with the interest. So no one can enrich himself at the cost of others. Equity principles. అక్కడ ల్యాండ్ మోటర్గేజ్ ఉన్నది, మరి అక్కడ అంత ల్యాండ్ ఇక్కడ తీసుకున్నారనుకోండి, then what will happen? He will enrich himself double. So that amount will be paid by auctioning this land to selling to somebody else, which is proportionately given to him what he left in Pakistan. So mere good faith is not sufficient. The purchaser must establish that he made a reasonable inquiry. So the person should have established that he has taken the lot of inquiry and the revenue records and not documents of title, and therefore it is not sure to rarely on the entries made in the revenue records. So never believe in the revenue records, please, because revenue records will be manipulated. Don't believe in the revenue receipts. It will be manipulated. Then what should be believed? Only a registered document. A transferee who relies on the revenue records and fails to inquire about the title of the transferor is not protected by section 41. సార్ రెవెన్యూ రికార్డు చూసినాం సార్ మేము ఎలక్ట్రిసిటీ బిల్ చూసినాం సార్ ఆయన పేరు మీద ఉన్నది సార్, ఎలక్ట్రిసిటీ బిల్ ఆయన పేరు మీద ఉంటే ఆయనదే అన్నట్టు అండి ఇల్లు.
నో సార్, నో.
మన కిరాయిలో కూడా ఉంటది పేరు అక్కడ. So merely those revenue records and other things will not be a right things to make it out. So it was observed in the case of the Pratap Chand versus Saida Bibi, a person who purchased the property from the ostensible owner, relying solely on the fact that his name was recorded or entered in the revenue records. Putti revenue records matram unnanta matrana is not the property holder. Only for a few years and did not inquire further is not entitled to the protection of the section 41 of the TP Act. సో అతనికి టీపీ యాక్ట్ సెక్షన్ వర్తించదు. ఎందుకంటే రెవెన్యూ రికార్డు చూసినామట, అంటే బోర్డు పెట్టిందనుకోండి, ఇల్లు హుస్సేన్ మంజిల్ అని పెట్టుకుంటారు బోర్డు, అంటే ఇప్పుడు హుస్సేన్దా అది చూడాలి, అది ఆ పేరు ఆ ఇల్లు ఎవరి పేరు మీద రిజిస్టర్ అయి ఉన్నది. ఎస్ సార్,
లింక్ డాక్యుమెంట్ ఈసీ చూస్తే దాని ల్యాండ్ హిస్టరీ వస్తుంది సార్.
అంతే, అదే లింక్ డాక్టర్ చూస్తే వీడు ఎక్కడికి వెళ్ళి కొన్నాడు, వాడెక్కడికి వెళ్ళి ఉన్నాడు, వాడెక్కడికి వెళ్ళి కొన్నాడు చూస్తే అన్ని తెలిసిపోతాయి. So that is a very much important factor. One should have to know it. The time is out.
బ్యాంకు లోన్ ఇచ్చేటప్పుడు కూడా అడుగుతుంది సార్.
Oh, they will see the everything link document definite అడుగుతుంది లోన్ అంటప్పుడు. మీరు బంగారం పెడుతున్నాడు, వాడు గోల్డ్ స్మిత్ ని పట్టుకొస్తాడు, చూస్తాడు ఇది 22 క్యారెట్స్ 18 క్యారెట్స్ ఇది బంగారం ఉన్నదా లేకుంటే కోటింగ్ ఇచ్చారు రా. ఎస్ 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 మొత్తం చూస్తారు, చూసి దాని వాల్యూ కడతాడు, కట్టిన తర్వాత ఎంత ఇవ్వాలని వాడు చెప్తాడు. ఇంత ఇచ్చు సార్ అంటే మరి వాళ్ళు కరెక్షన్, మరి గోల్డ్ స్మిత్ వాడు పెంచుతాడంటే మరొకరికి కదా ఇచ్చింది వాడు, మరొకరికి పెంచుతాడు కాబట్టి దే విల్ కట్ ఇట్ ఆల్సో, దట్ థింగ్. So all the things will be taken into consideration before making any transactions, and so that is the must for that every person to do so. With this, my time is up, and we'll see the rest of the portion in the next class. And by that, I would like to say goodbye and see you tomorrow at the 3:15. The time is 4:01. The rest of the part that I will cover it later. Have a good
Thank
day.
you so much, sir.
Welcome, welcome, sir. Welcome, sir. Welcome. Yes, the end of the meeting. Yes.